Hello friends, welcome to video lecture on Muslim law. I'm Marjina Sultana, an assistant professor from Interpersonal Law College, Greater Noida. Today we will be discussing marriage under Muslim law. Let's get started our discussion with the definition of nikah. Nikah is an Arabic word which literally means the union of the sexes, and in law this term means marriage. In Bailey's Digest, marriage has been defined to be a contract for the purpose of legalizing sexual intercourse and procreation of children. In Hidayah, it is defined as nikah in its primitive sense means carnal injunction. Some have said that it signifies conjunction generally. In the language of law, it implies a particular contract used for the purpose of legalizing generation. Muslim marriage is a civil contract as well as a devotional act. Some jurists are of the opinion that Muslim marriage is purely a civil contract, while others are of the opinion that Muslim marriage is a sacrament in nature. Let's look at the observation made by the Justice Mahmud in Abdul Qadir versus Salima. Marriage among Muhammadan is not a sacrament but purely a civil contract. And though it is solemnized generally with the recitation of certain verses from the Quran, yet the Muhammadan law does not positively prescribe any service peculiar to the occasion. So, according to the Justice Mahmud, Muslim marriage is purely a civil contract. His observation is based on the validity and the operation of the whole, that is validity of the nikah is made is dependent upon the declaration that is making offer and the acceptance of that proposal, that offer. And also there is the consent of the contracting parties are very important. It is mandatory, the consent, the free consent is important. So, and these contract has to be made before the competent and sufficient witness. So it is a civil contract, but it is more than a civil contract. It is also a devotional act. So let's look at the reported traditions of the Prophet Muhammad, which says that marriage is essential. It is essential for every physically fit Muslim who could afford it. Another hadith of the Prophet Muhammad, peace be upon him, says that he who marries completes half of his religion. So the half of the religion is completed by marriage, by having a marriage, because the marriage leads a person to a virtuous life by avoiding illegal unlawful relationships. The another reported hadith of the Prophet Muhammad, peace be upon him, is that there is no monkery in Islam, which means there is no monasticism in Islam. The general essential of a valid nikah is, the first one is proposal, ijab, and the acceptance, that is qubul. So like any other contract, marriage is also constituted by a ijab or qubul, which means that one party to the marriage must make an offer or ijab to the other party, and the other party must accept that offer, that proposal. And the marriage becomes complete only when the other party accept that proposal. It must be noted here that the proposal and the acceptance must be expressed at one meeting. So if a proposal is made at one meeting and the acceptance is made at another, it does not constitute a valid marriage. It must be the proposal and the acceptance must be made at one meeting. The second essentials of a valid nikah is is that the parties must have capacity. The parties must be capable to marry. It means that the parties to the marriage must have the capacity of entering into a contract. So the capacity here, the capacity means the parties must be of sound mind, and they must have attained puberty. It is also important to remember that the marriage of the child marriage is invalid if it is not accepted by the guardian, if it is not uh, the consent of the guardian is important for the child marriage, unless that marriage that this the marriage is ratified after the attainment of the majority. So for a child marriage, consent of the guardian is important unless ratified after the attainment of majority. And under the Child Marriage Restraint Act of 1929, child marriage is a valid marriage. But the parents or the guardian who conduct such child marriage are punishable. They can be punished. They can be punished under the act, but the child marriage is a valid marriage. The third condition of a valid nikah is that there must be a free consent of both the parties. Here, free consent means the consent must be a voluntary one. It must not be received under compulsion or under undue influence or by fraud or by coercion. The fourth essentials is the consideration, that is meher. Meher is mandatory for a valid nikah, and it is to be given by male parties to the female. The fifth condition is there must be no legal impediment. There must be no legal disability. The sixth condition is the sufficient witnesses. So, sufficient witnesses means under Sunni law, there must be two male witnesses or one male and two female witnesses, and they must be sane, adult, and a Muslim. But under Shia law, the witnesses are not necessary for a valid marriage. But under Sunni law, there must be either two male witnesses or one male and two female witnesses. Now let's understand the effects of a valid marriage. First, the cohabitation between the husband and the wife becomes lawful. Second, the children born out of a valid marriage are legitimate, and so they have the right to inherit their parents' properties. Third, mutual rights of inheritance between the husband and the wife are established. So, after the death of the husband, the wife is entitled to inherit the husband's properties, and after the wife's death, husband may also inherit her properties. The fourth effect is prohibited relationship for purpose of marriage is created between the husband and the wife. It means that each of them is prohibited to marry the relations of the other within prohibited degrees. Another effect is that the wife's right to claim dower, that is meher, is fully established just after the completion of marriage. The sixth effect is the marriage gives to the wife also the right of maintenance from her husband with immediate effect. So just after the completion of the marriage, the wife can claim maintenance from her husband. The seventh effect is after the dissolution of the marriage, the widow or the divorced wife is under an obligation to observe the iddat during which she cannot remarry. Registration of marriage in Muslims is compulsory and mandatory as Muslim marriage is treated as a civil contract. According to Section 3 of Muslim Marriages Registration Act of 1981, every marriage contracted between Muslims after the commencement of this act shall be registered as hereinafter provided within 30 days from the conclusion of the nikah ceremony. Nikahnama is a type of legal document in Muslim marriages which contains the essentials, conditions, or details of the marriage. So, this is it for the Muslim marriage. Thank you for watching.